Hello, class. I hope you are having a good virtual day. Today, we're going over the civil procedure. So, it's kind of similar to a criminal procedure, right? And the fact that you sometimes go to court, you have a judge, you have a jury, but there are a few things different. So, we'll kind of go over those right now. All right, so the first one in a civil proceeding, you have two type of remedies. So you have injunctions, which are a court order for a person not to do something. So a lot of times this will be on minor cases. Most of the time, there's no other offense that the person has committed. Just a slap on the wrist. It's basically the court saying, "Hey, don't do this again. If you do it again, you're going to be in more trouble." Then there's damages. So there's two types of damages. There's compensatory, which place the injured party back in the position where they were before. I would look at this as like a wrongful firing. Someone gets fired for something, and the court says, "Hey, you can't do that." A compensatory damage would be to put that person back in the position they were before. Punitive is a little different. These are the ones you hear most of. It's typically awarding the injured party money. So it punishes the person. Most of the time, that punishment is, hey, you did this wrong. You have to pay this person so amount. So one thing to look at before you are going to take someone to court, all right, are lawyer fees. And these are not cheap. All right, so lawyer fees are either paid in two ways: an hourly rate or a percentage. So I just hopped online and I looked at what the average rate for lawyers was per hour in the US. And about any state you go to, it ranges from $200 to $300. New York is a little higher, California is a little higher, but most states in the Midwest and around here are 200 to 300 an hour for a good attorney. The other way attorneys can be or charge you is off a contingency. So what happens most of the time here is when you win, you get that settlement, and they take a portion of what the punishment is for the other person. So say that you settle before trial, the person gives you $100 to go away, then the lawyer would take 25% of that, so they get 25 of $100. If you go all the way to trial and you win, then you get 33%. The lawyer gets 33% of the winnings. And then if you don't win and you win on appeal, then you get 40%, or you get 40% to the attorney. And this kind of makes sense, right? Because the attorney's doing less work if they settle before trial. If you go to trial, you're doing a little more work. And then obviously, if you have to appeal it and win, then you get the more money. They're doing more work. Um, Contingency fee is nice if you're not sure you're going to win, because you don't have to pay anything if you lose, right? But you could also be paying a lot more depending on what it is if you win and have to pay them all that money. For those of you who know Mr. Fugate, he was a teacher here before I was. He was a lawyer before he started teaching and is going back into law. And after seeing the slide and doing this research, I kind of understand why. That's a lot of money to get paid. But lawyers work really hard too, so it's deserved. All right, so criminal procedure, right? So there's a few steps that you go through when you take a civil case to court. So the first one is just initializing the case. All right, so a few definitions to know. The plaintiff is the one who files the complaint. So if you were to take someone to court, you'd be the plaintiff. Defendant is the party complained against. So say you did something wrong and someone took you to court, you'd be the defendant. The complaint itself is a legal document that initiates a civil court case, and a summons is something that is served, or someone that is served with a complaint that demands a court appearance to answer the questions. Then we look at two things. So the first one is answer, and this is done through lawyers. If you don't answer the summons in a timely fashion, then there's a default judgment. So the judge will just look at what went on, make the judgment without ever hearing the case. Once you do answer, you're going to go through something called discovery, which is where lawyers kind of talk to each other, look at the case, and try to find out exactly what's going on. So the first one is depositions. So this is where they will bring you in. They will ask you questions in person. You are under oath, and this will all be used in the trial. And then interrogatories are kind of a list of questions that are sent back to the attorney. So one attorney will send your attorney a list of questions they need answers to. Your attorney will get with you to get those questions answered, and then they will send it back to the other attorney. These will sometimes be used for a deposition, so they'll look at those and formulate questions based on that. If it goes to trial, a lot of times this will be used as a line of questioning for them to ask you when you're on the stand. So in civil cases, you kind of get two options. So you have a judge or a jury. So if you're just using a jury, the judge will decide the issues of law, jury will decide the issues of fact. In most jury cases or trials for civil cases, kind of ranges from 6 to 12 jurors. In most states, it doesn't have to be unanimous. So if a certain amount of jury agree with what the outcome should be, that is what they'll go with. If there's no jury, the judge will decide both the matters of law and decides the issues of fact. So procedure continues. So once you go to court, it's going to be kind of like the Big Bad Wolf case we just did, right? You'll have your opening statements and testimonies. Attorneys will make the opening statements. Evidence is presented by the plaintiff. Then evidence is presented by the defendant. The evidence can include testimony. It can include physical evidence. It can include what was brought up in discovery, depositions, and so on. Then you have closing arguments, which again we kind of just learned at in the Big Bad Wolf case. You guys thought it was funny, but you see, you actually learned something from it. The closing arguments are just oral statements made at the conclusion of litigation by attorneys. Then the juror will get the instructions from the judge. They will deliberate. Which means they retire to the jury room. They look at all the evidence, and then most states, Indiana included, a unanimous vote is not needed. Most of the time, if it's 12 jurors, it's 10 out of 12. If it's 6, it's just 5 out of 6. The verdict is reached, and then the judgment, which is the final result of the trial. Another term to note is the writ of execution. The judge will issue an order if the defendant fails to pay after a judgment has become final. So that's something, if you don't pay what the judge tells you to, then you get in a little more trouble. And that is it for today. So there's a video that I posted on here. This kind of walks you through the whole civil trial procedure. I think he does a good job. I think you guys will actually gain something from it if you watch it. Sometimes people can explain things a little better than me. So I would definitely take a look at it. You also have a Chapter 5 review guide. We'll go over this in class next week to make sure you guys get the right answers, but it will be good for you to study for on the test. My son, Jonah, who is a second grader, would like to say something to you. Jonah, would you like to come here?
Subscribe and slap the bell and turn on all those notifications.
That's right. Subscribe to my channel. My kids want me to be as popular as, I just heard, like there's some guy named PewDiePie and Mr. Beast. So I am going to be a new Mr. Beast, I guess. All right, guys. But seriously, have a great weekend, and I will see you in class either tomorrow or next week.